Good afternoon, everybody. Thank you so much for the opportunity to present the right to legal aid in the context of international judicial cooperation towards the improvement of equal access to justice for all. This brief literature review was jointly developed by Pedro Liberado, Pedro das Neves, and myself, Joana Apóstolo, at Innovative Prison Systems. Being involved in criminal justice procedures may entail tremendous challenges for a substantial number of individuals. The United Nations acknowledges that safeguarding procedural rights is not always easy, especially in what concerns legal aid. In fact, it is still far from its ideal implementation, even as Directive 2016/1919 aims at closing existing gaps in the European Union space. Its adoption goes hand in hand with the ever-increasing perception at academic and policy levels regarding the links between justice, poverty, and inequality. In fact, insufficient access to legal aid carries devastating consequences to individuals involved as suspects or accused in criminal proceedings. What's more, it fundamentally calls into question the fairness and equity that should normatively characterize judicial systems. Yet, and despite the efforts from the EU and from the overall international community, several elements contribute to hindering this right's full implementation and respect. An imbrication of multi-level issues and difficulties ranging from the posture of police officers as first-line practitioners to the international divergences in judicial systems create severe and long-lasting impacts in this context. Our proposal seeks to explore the present and prevailing obstacles to the respect of this right in the EU space, while keeping in mind the continuous efforts for building a fair and inclusive society which guarantees access to justice for all in line with Sustainable Development Goal 16. To this end, we will first look into the directive itself, as well as its context and provisions. This first moment will allow us to better understand the prevailing critical issues which hinder the full implementation of the directive itself and, consequently, the right to legal aid. We will strive to comprehend how these obstacles stem from an ongoing, yet fundamentally unachieved, integration project, which are further densified by the practices of frontline professionals involved in the provision of legal aid. We conclude that deepened interinstitutional cooperation is necessary, both at national and cross-border level, so to achieve the fairness of criminal judicial proceedings and the inclusion of all members of society. EU's Directive 2016/1919 specifically translates the efforts to countering operational issues which hinder the proper functioning of legal aid provision systems in the EU member states. At its core, this directive seeks to support vulnerable individuals who lack sufficient financial resources to meet the costs of a court case or legal representation, while, of course, ensuring the fulfillment of the right to a lawyer. Before delving into the tension points related to this issue, it is first important to determine our interpretation of legal aid, which shall frame the presentation. By legal aid, we refer not only to legal representation, such as the right to a lawyer, but also to the fulfillment of public access to law, in itself also linked to the right to legal information, legal advice, and knowledge. Its qualification as a right to rights by academia is therefore due to its role as a fundamental prerequisite for equitable, humane, and effective criminal justice systems. This directive is generally recognized as a step in the right direction. However, in the context of the European Union, many issues remain to be tackled. The first noteworthy factors are the blockades associated with the differences in EU member state judicial systems. While legal provisions concerning the right to legal aid are defined in all EU member states' national legislation, the directive's implementation is not always guaranteed. In fact, the directive finds its inspiration in Article 6 of the European Convention on Human Rights. However, the latter does not put forward concrete guidelines for its translation into practice. Consequently, EU member states enjoy the responsibility of freely deciding on which means should be mobilized according to individual national standards. For instance, the directive imposes the provision of legal aid be available at the latest before questioning and even before relevant investigative and evidence-gathering acts begin. Regardless, in Greece, for example, suspects are usually not granted legal aid until they are brought before a judge. On the other hand, the Italian system entails such complex bureaucratic procedures for legal aid provision that they cannot really be fulfilled while the suspect is under police custody. This situation proves problematic by harming the quality of the legal aid service provider's work and consequently calling into question the fairness of criminal justice proceedings. The work of professionals involved in legal aid proceedings is another important element, notably because of the manifest shortcomings on the practitioner's side related to informing the individuals of their rights, for example, regarding cost exemption. This is namely the case of Hungary, whose legal aid system also covers the fees and costs of the ex officio appointed defense counsel. However, suspects and accused people are not properly informed and cannot take advantage of this possibility. The Bulgarian system shows some similarities in this regard, as police detainees are entitled to legal aid but are again not informed of this fact by law enforcement agents. Moreover, it is important to highlight that the approach adopted by police officers often conduces to the violation of procedural rights, since, in several occasions, the individual in question is not assigned the status of a suspect as a deliberate strategy aiming at avoiding triggering his or her rights. Alternatively, law enforcement agents often use legalistic language, which in practice is not intelligible for the individual in question, hereby hindering the individual's understanding and access to legal aid. Additionally, defendants often state not to have been involved at all in the choice of their legal representative, or that they were not even aware of this fact, as a result of these poor practices by first-line practitioners. In the midst of such a complex field of work, the role of legal aid service providers takes on a renewed importance. Regardless, literature highlights the lack of quality of their work, inadequacy of their skills, or poor working conditions. In fact, several reports underline that individuals involved in criminal proceedings didn't feel effectively represented by their assigned defense lawyers, as put forward by fair trials. However, it is not always easy for these practitioners to access further training opportunities, as they are usually overburdened with cases and usually receive substantially lower pay in comparison to their private colleagues. The introduction of international judicial cooperation instruments, such as the European arrest warrant, creates other issues for the fulfillment of the right to legal aid, by demanding a closer interaction between very different judicial systems and first-line practitioners and legal aid service providers, thereby exacerbating these pre-existing flaws. This mechanism aggravates the difficulties pointed so far and poses additional obstacles. For example, in what concerns the respect for provisions such as the right to access to information in a language the suspect or accused person can understand. Also, the specialization and skills of the state-appointed lawyer might not be adequate to the case in question, especially in what concerns EAW-specific proceedings. In reality, some lawyers might not possess enough knowledge or experience in what concerns the judicial system of the issuing state, hindering the full respect of the right to information and subsequently the right to legal aid. The erosion of the overarching principles meant to guide our justice system is further deepened by the concrete and practical negative consequences faced by the individual. As a result of these factors, suspects or accused people are often prevented or discouraged from exercising their rights, leading to the legal underrepresentation of economically vulnerable groups. In turn, SDG 16 is also undercut, as the present situation actively prevents equal access to justice for all. Against this background, moving forward will mean that national and transnational cooperation must be promoted between law enforcement agents and judicial practitioners in order to achieve systematic access to information and the respect to the right to a fair trial, along with training opportunities to the involved actors, as previously called for by the European Commission. The Explored Directive is granted even further relevance when considering that the time limit for its transposition was just last year. Difficulties in its implementation are expected and will only become more evident with the passing of time. Therefore, this is an objectively appropriate moment to work towards the successful implementation of its provisions in EU member states and ultimately towards the fulfillment of SDG 16 on promoting peaceful and inclusive societies, providing access to justice for all, and building effective, accountable, and inclusive institutions which provide access to justice for all. However, it is not possible for professionals to guarantee the legal representation of vulnerable individuals in such a complex and diverse transnational context if they are not trained to take on a holistic approach. A balanced approach must be adaptable and sensitive when it comes to marginalized communities, for example, from a lower socioeconomic background, having lower literacy levels, or even considering mentally ill individuals, thus guaranteeing the fairness of criminal justice proceedings and the inclusion of all members of society in pursuance of an efficient justice system. Thank you very much.